that a doctor would look at to determine whether a embryonic, a unborn child has progressed from the embryonic phase to the fetal phase?
I'm not a doctor, Your Honor, and I don't think that this is in the record, but
then,
I think
okay,
that
it's
there
not in the
are
record.
other markers.
It's not in the record.
There are other markers of development in addition to the crown rump length.
Let me ask
Last question on that point, and then Justice Verdon, but would you agree, though, that when medical people would try to answer this question, that they would see one person might see it differently than another person?
I think it is possible that one person might see it differently than another person. And I think that that goes to our alternative vagueness argument, that it's not only doctors who need predictability and certainty as to how they should.
Well, I don't see how you can argue that the use of the term fetal makes the definition clear and unambiguous, but on the other side, the fact that the word fetal can be looked at differently by different doctors makes it unconstitutionally vague.
I mean, I think this is an argument in the alternative, Your Honor. I think the better argument is that it is unambiguous, that the text speaks for itself and that the text is clear. But if you're not convinced by that, we do think that there's essentially then a divide. If you think that the term fetal does not control the outcome of this case, that there's then a divide between the stage, if you're interpreting it to say that it applies at 6 weeks, and then, but it's regulating embryonic, essentially abortions when the pregnancy would be an embryo, that's in contrast to how a doctor would interpret the term fetus.
Thank you so much. Justice Verdon has a question.
All right, and just to ask you some questions about this, your argument that this is unambiguous to begin with. First of all, let me just be clear. You believe the definition of the fetal heartbeat is one point in time. You and the state don't agree on the time, but you both agree it's one time. Is that correct?
Yes, that's correct, and that's based on the legislative finding.
And my concern is, as I was looking through the record, Dr. Ferris's statement that I have not understood at what point in pregnancy fetal heartbeat is defined by the Act refers to, or if it refers to a singular point in pregnancy at all, given the ambiguity raised by the court. So if your own expert is saying that the statute is ambiguous to her, how can we not then turn and look at legislative intent?
So I think perhaps ambiguity might have been a poor choice of words there. I think there's a difference between uncertainty and ambiguity. And the other thing I would note is that with vagueness, as with ambiguity, it's an objective determination. So one doctor's subjective view of, I don't know what this means, while it might be evidence of ambiguity or unconstitutional vagueness, that's not what holds the day. And what holds the day is this court's interpretation of the text itself. And the court's analysis can end with the text, and it should only, as you note, turn to external sources of legislative intent if it determines that the language itself is ambiguous. And then if it's ambiguous, it should apply the accepted canons of construction which focus on the text before turning to extra textual sources. So as Justice Hill recently noted, extraneous sources represent unenacted legislative intent at best. By contrast, focusing on the text allows the court to provide a principled approach to ascertain the statute's meaning without second-guessing the General Assembly's policy determination. And I think taking a principled approach is critically important in a hot-button political case like this. So as the court wrote in Planned Parenthood 2, the court should not turn its back on legislative deference merely because the issue is abortion. So I'd now like to talk about the points of types of legislative history that I think you should consult, and this is only if you first determine that the act is ambiguous.
Let me follow up on Justice Verdon's question. You both seem to agree there's one point in time.
Correct, Your Honor.
They say 6, you say 9. But in all these materials that I've read, and even in some of the arguments in these briefs and in some of the legislative history, it says things like somewhere between, or roughly, or about. How in the world is that one moment in time?
So, Your Honor, I think that this goes to two separate factors that
and let me be a little absurd here. On Friday, no. On Sunday, yes. So what about Saturday? Where is the moment in time? Could it happen on the way to the doctor's office?
I think it potentially could. I mean, I think that this goes to
How does that
what
give anybody any certainty?
So I think that they're planning to Justice Few for doctors to clearly determine when you would reach the mark that we're referring to. But I think that there's sort of two parts of the definition of fetal heartbeat in this case to break apart. And there's fetal, and that is a definitional term that has some sort of certainty. As we've noted throughout our papers, these other markers are developmental, and developmental processes may vary. I think the legislature recognized this when they said normally when the fetal heart forms in the gestational sac. And so, but I think that this goes to the deference to the legislature. The legislature is free to define things as they wish. And if they say it's one moment in time, though, as a matter of medical development, there is variation. But what the legislature says has to rule the day. And I think that this is why the use of the term fetal is so critical, because there's a clear line on either side of that.
Sorry to sidetrack you.
No, that's all right, Your Honor.
Let
turning-
me ask something, if you don't mind. I know we can go back and forth, and we can turn to the conflicting medical opinions, the battle of experts to discern legislative intent. You mentioned deference to the legislature, and our mission here is to discern legislative intent. And I think we all acknowledge that the statute is not written with absolute precision. And I think that sort of pushes against your argument that it's unambiguous. And I note parenthetically that you also make a void for vagueness argument, which I'm not sure how flies with your threshold argument of unambiguity. I also understand the principle that we do not discern legislative intent from after the fact statements from members of the legislative body. We look to the text. But this is an unusual situation in that we have, prior to the passage of the legislation, everyone, proponents of the legislation and opponents of the legislation, without exception, referring to this as the quote 6-week bill. That same mantra and narrative was picked up, as alluded to earlier by Justice James and Justice Few, that was pushed by Planned Parenthood. So how do we reconcile our obligation to discern legislative intent with what we know all the legislative body understood prior to passage?
I don't think it's fair, Your Honor, to say all of the legislative body knew this prior to practice. So in the governor and the attorney general's brief, I counted maybe a dozen individual legislators who it cites. But there are 170 members of the General Assembly as a whole, and this court shouldn't give effect just to the loudest voices in the room. So there's a lot of sausage making that goes on behind the scenes, and floor debates are part of that. But to speculate as to what the other 158 members of the General Assembly thought is not to give effect to the text. And I think that this goes to the types of legislative history that the court should rely on before statements of individual legislators, and those are grounded in the text.
That's a fair point, but we don't just have 10 or 15. We have so many members of the legislature. In fact, there was an effort to put amendments, tons and tons of amendments. And through that process, by the opponents of the bill, we learned what the view was about what the intent of the legislature was. The 6-week bill, which mantra was picked up by Planned Parenthood.
I think the amendments are critically important to this because they also speak to, if the legislature voted those down, that speaks to the voice of the whole legislature. And so there were 2 amendments introduced that would have substituted embryonic or fetal heartbeat. And the legislature declined to include the term embryo here. And as Justice Hill noted previously, the legislature knows what embryo means and it knows how to use it when it's there. The second I would point to is amendments that would have substituted the definition of unborn child for human fetus. And that's again, one of the critical differences between SB1 and SB 474 is that human fetus is undefined. And so the legislature specifically chose not to say that human fetus is from the moment of conception. And so that then moves this court into the common understanding of the term fetus.
Fair point. Thank you very much. Justice Burton asked an excellent question, and you were going to talk about rules of statutory construction that you believe support your position. Justice James asked a question, then I asked one, and I apologize for that, but I want to give you an opportunity to address the points you were going to make earlier.
Sure. So I think just to continue with the types of legislative history that this can rely on, I'd also just like to zoom back and talk about what the legislature's intent was. And so the intent was to ban abortion after the detection of a fetal heartbeat, not to ban abortion at a specific point in time. And the legislature specifically gave some opportunity for some more limited number of abortions to occur. But when the legislature wants to talk about a specific gestational age, it knows how to do so. But you will not see the term 6 weeks anywhere in the text of the fetal heartbeat ban. And this is in contrast to the rape and incest exception, where it specifies 12 weeks. And another sort of legislative history that you can look to is prior enactments of the General Assembly. And the General Assembly previously enacted a 20-week ban. And so if it wanted to enact a 6-week ban, it could have, and it chose not to do that. I think a third source or another source of legislative history is this idea that similar laws from other states can be construed similarly. And the court should assume that any changes between South Carolina's law and similar so-called heartbeat bans, those differences have to have significance. So we've noted some of these on page 20, footnote 7 of our brief. In addition to those, I'd also note that Ohio, Kentucky, Mississippi, and Texas all have materially different definitions of either fetal heartbeat, fetus, or unborn child. And so I think that this goes to the idea that South Carolina's law is different, as Justice Few noted at oral argument last time, from Texas's, for example.
Have you been able to detect any reason why South Carolina, the General Assembly inserted commas?
I don't know the reason for that, Your Honor. I don't want to speculate
It's
as
not anywhere in any of this history.
not to my knowledge. I think that there was one amendment which would have introduced the definition, would have introduced the term embryo as well as fetus that removed the commas, but I'm not sure the reason for that, and I don't want to speculate. And I think that that goes to why the court's interpretation should be grounded in the text, because we're not here to speculate about legislative intent. We're here to give effect to the plain language. Just very briefly in my remaining time, I'd like to turn to the rule of lenity. And its application is.
I want to, before you go there, I don't know whether the chief is going to be strict with your time or not, but I have maybe two more things I want to ask you about. One is we've heard throughout this entire process here in South Carolina, and in fact, as similar legislation has been introduced and debated in other states, we hear the same thing. And that is that the reason this point in time was picked is because at that point in time, once that point in time is reached, there's a 95% correlation between reaching the point in time and an eventual live birth. So from when taking that idea right there, what is your understanding from a medical standpoint of which is the point in time that has the 95% correlation? Is it what you argue or what they argue?
So I think this is another critical difference in the legislative findings between SB1 and SB 474. So the finding you're referring to, Justice Few, appeared in SB1, but doesn't appear in SB 474. So the idea that we could take this 95%.
All right, I got that, but answer my question.
I don't know what the point in time is. It's not in the record here. And I think that there's, a host of different variation in fetal development, so that, one person's developing pregnancy might have a 95% chance of being carried to term at, let's say, 10 weeks, and another person, it might be 6 weeks, and it might depend on, the age of the pregnant person, for example, other factors like that.
All right. Well, in the first argument, which you didn't argue, I think Ms. Murray argued that. There was a sequence of events that I want to ask you about. The idea that Planned Parenthood asserted from the very beginning is that this abortion cutoff ban takes effect before, different words have been used, vast majority has been used, substantial number, but before some large number of women even know that they are pregnant. So that was the kind of how this whole idea began, as why this bill would be unconstitutional. During the course of the first argument, Justice Kittredge pointed out to Ms. Murray that there's data in the record from DHEC, our State Department of Health, that something like 45% of abortions that occur in South Carolina occur within 6 weeks. You remember that?
Yes, Your Honor.
All right. Ms. Murray then responds to Justice Kittredge by saying that data is different. That data is measuring from the time of conception rather than from the time of LMP. So she responds to him, what that data really is talking about is 8 weeks in terms of what we're talking about here. And then I followed up with her by saying, okay, well then, and with the state too, what is the data? And the answer that I got from both sides is that there actually is no data. But now that your position is different, wouldn't it be true that that 8-week data, that 6-week data is right on point, down the heart of what I was pressing on from day one in this case?
So quickly, I don't think that the constitutional point should turn on the number of people that
You
know
might
they're
not think
pregnant,
that.
but
You might not think
I
that,
hear the
but
court's ruling.
you
and-
read what I've written and
Yes.
you've heard what I've said, so it's
Yes, Your
important to me.
Yes. And I think to the extent that the court is going to consider statements from individual legislators, which, I would really
Let's stay
caution
focused.
against
We're
that.
out of time. Let's stay focused.
The statements from the bill sponsor in the journal relies on the DHEC data in offering that essentially that data is on point precisely in the way that you say it is. And so to the extent someone's offering a justification to that, I do think that supports our point. Again, I would caution against sort of how individual legislators can kind of manipulate the record and not speak for the legislature as a whole. But I do think that data is in
Well,
there,
I
as
think
well as in
I-
Dr.
I'm-
Ferris's
if
declaration.
the chief was going to permit me, we're going to get to the heart of this. We have these principles of law that we've written about that say that the legislature is presumed to know what the court has said and about what the law is. Would it not also be true that the legislature is presumed to know what the administrative agency that is tasked with the very subject matter of the legislation under consideration has said about what's going on in our state?
I do think that's correct, Your Honor. And I think that
Okay.
the DHEC, or now Department of Public Health, milestones support us. So they say that, it's a fetus
What
only.
do you think? Now, you've read my opinion in 1 and 2. If I had in my hands, data showing that almost 50% of abortions actually do take place during the period of time when the act permits it. And if I was aware of this principle that you and I think have just agreed on, that the legislature is presumed to be aware of that, how would that have affected my opinion in the first case?
Well, I think that that's maybe a bit subjective as far as having, what is a substantial number. As you noted, there's a number of different turns of phrase that have been.
Yeah, but remember what I said in my first opinion. I was very pointed in saying it's not up to the court to determine what is the correct or sufficient number. That would be up to the legislature. My point was that the legislature hadn't even considered it. But if they had, if there were data that shows where the point is, and the legislature is presumed to have had that data in their scope of materials that they're considering during the legislative process, presumably they would have considered it. How would that, you don't have to answer the question. It's a rhetorical question, but it's a serious question. The point being that if we had started this process with y'all taking the position that this is not a 6-week bill, but a 9-week bill, then the outcome of Planned Parenthood 1 would probably have been different.
I take the point that it's a rhetorical question. I think, that perhaps should have been the case, but I would just again point to the differences when the legislature said, okay, we're considering this data that Justice Few told us to, and we fixed it. I think that those are where the differences between SB 1 and SB 474 come critically into focus. And, I know that my time is up, Your Honors. I also,
Time and reply as well.
okay. Thank you, Your Honor.
Thank you so much. Counsel?
Mr. Chief Justice, and may it please the court. For the third time in as many years, abortion is back on this court's docket. But unlike the first two cases that involved a facial challenge, this one involves a narrow yet important question of statutory interpretation. What does fetal heartbeat mean, such that the 2023 Act's protections for unborn life apply? The circuit court said it was clear beyond a shadow of a doubt that that point was approximately 6 weeks, and the circuit court was correct. The text confirms this conclusion. Fetal does not draw the bright line at 10 weeks that my friends suggest. A heart exists from at least 5 weeks in pregnancy, and there is evidence to support the General Assembly's conclusion that a heart at approximately 6 weeks has a steady and repetitive rhythmic contraction. But at best for appellants, given all that this court said about timing in Planned Parenthood 1 and all that appellants themselves have said about the timing of the 2023 Act, the term is ambiguous. If that's the case, all the tools of statutory construction, including and importantly the legislative record, are before this court, and the conclusion is the same. The law protects unborn life from approximately 6 weeks, and this court should therefore affirm. I'd like to jump directly to what was the heart of the conversation with my friend on the other side, and that's the meaning of the word fetal. And I've got at least 4 reasons fetal does not draw a bright line at 10 weeks of pregnancy in this act. Number one is fetal heartbeat laws across the country generally. They have consistently been understood, no matter what the definitions are, to apply at approximately 6 weeks. For instance, take Texas. When its law got to the U.S. Supreme Court, both Chief Justice Roberts and Justice Sotomayor called it a 6-week law. Second, we have academic studies that use fetal to mean something less than 10 weeks. So for example, the Journal of Human Reproduction, that's a peer-reviewed publication from Oxford, has studies going back at least 24 years that uses the term fetal cardiac activity or fetal heartbeat to identify pregnancies for studies at less than 10 weeks. Third, you have the Act's findings itself. The Act in Section 1, Subpart 3 says a fetal heartbeat is a key medical predictor that a child will reach live birth. Justice Few, you connected that in Planned Parenthood 2 to the 95% finding in the 2021 Act. And I would note the other finding in the 2021 Act talks, that was finding 1.1 about a fetal heart protecting unborn life. This point we're talking about, Justice Few, to one of your last questions to my friend, was, are we talking about the approximately 6-week point or the approximately 10-week point? It's that 6-week point. That's what that 90+% studies go to.
And you're going to tell us, but how do we know that?
How do we know that? I think this is important. I want to put the court. Let me start. I want to point the court to Owens because I think Owens is instructive on this point. Last summer, this court explained in great detail the deference that is due to the General Assembly and its legislative findings. They can be expressed, but as this court noted, they can also be presumed. And as long as there is any evidence to support what the General Assembly did, as long as it's not clearly erroneous, there must be deference to that. So a couple of places we can point to, the studies I referenced earlier. You also have, for example, the American Association of Pro-Life OBGYNs had an amicus brief in Planned Parenthood 1, where at page 7, they're citing a book by Keith Moore called The Developing Human that explains how there is blood pumping through the unborn child at the end of the 5th week. That is all evidence that says there's a heart, it's functioning, there's a steady and repetitive rhythmic contraction. I appreciate that my friends on the other side may disagree with that conclusion and may go the other way on the medical evidence. But as the court's opinion in Planned Parenthood 2 said, deference to the General Assembly is not diminished because there is medical evidence on both sides. In fact, the U.S. Supreme Court has noted when there's that type of evidence, perhaps even greater deference should be given. The General Assembly reached a conclusion here that there is a steady and repetitive rhythmic contraction of the fetal heart at approximately 6 weeks.
How do you get back will get past the fact that if you first look at the words on the page, don't dig into the past or the history. Stay with me there. The words 6 weeks are not in the text of the statute.
What the statute is doing, Justice James, is not drawing a bright line at a number of weeks or using a number of weeks as a heuristic for a
Okay.
point in pregnancy. Instead,
So that gets to the question of what's a fetal heart.
correct. And I think I've given.
What is it? In the medical science, what is it?
A fetal heart is a term that is commonly used both in academic publications, like I just mentioned, and in common usage in legislative debates in South Carolina and across the country to refer to a point in pregnancy at approximately 6 weeks when that heartbeat can be detected via ultrasound. But Justice James, I want to just say this perhaps. If you think fetal heart on its face has no clear meaning, at best it has to be ambiguous here. You've got this court and 4 justices more than 80 times in Planned Parenthood 1 calling it a 6-week bill. You have Planned Parenthood calling it a capital S, capital W, capital B, 6-week ban more than 300 times in their filings. And in Planned Parenthood 2, in their brief in that case at page 42, note 50, they called the 6-week mark the hallmark feature of the 2023 Act. If it is possible for the term fetal heartbeat to unambiguously mean 9 weeks, I don't think it's conceivable that any of those things I just described could have been true. I don't think there's any way 4 members of this court get an unambiguous term wrong in the same way. I don't think there any way lawyers get that term wrong in 2 separate cases in this court, plus cases in federal court. So if that's the case, Justice James, the term's ambiguous. And then you've got all the tools of statutory construction.